Morning, everyone. I'm in Seattle, Washington, so early for me. Hello, East Coasters. You've had more coffee than I have. Um, Tammy, Brian, and I are excited to present to you today about the brand business. What does today look like? We're going to be talking about policy, regulations, intellectual property, branding, some trade secrets, and any of the questions that you want to send. I'll be watching my phone here, and when they come in, we'll just address them as they come in. No need to wait to the very end. Before we get started with our introduction of our speakers, of course, we want to thank our sponsors. So Mood, Hardworking Cannabis. Mood is an online dispensary focusing on customers and the highest quality products. We encourage you to use the discount coupon available here. And Mood, thank you. You've sponsored each one of our cannabis CLEs. This is number 3 of 4, and we're so happy to have you as a sponsor. Additionally, Type to Learn, kindergarten through 4th grade, is the makers of the #1 typing app for education. And also we want to thank Max Assets. They involve restructuring, insolvency, Chapter 11, assignees, etc. Each of these sponsors have also been with us for all 3, and next Friday is our 4th presentation on cannabis topics. So thanks to both of you. Our disclaimer, we acknowledge that cannabis is still federally illegal. However, this is just for informational purposes. I am a lawyer. I am not providing any legal advice. Tammy and Brian and I, this is just for your information only. If you have any questions, you should actually retain an attorney or a professional and present your questions to them. All right, so just to recap, where we've been. We started off a few weeks ago with kind of Cannabis 101. Then we talked about insurance and risk and what has been happening there. Today, we talk about the brand. And then on Friday, we'll be talking about business valuation and how to assess the business and the value of it and the crops, etc. So meet the faculty who will be talking with you today. So we have Brian, we have Tammy, and then we have myself. So Brian, would you like to just say a few words to our audience?
Sure. So I'm Brian Landry. I'm a partner at Saul Ewing LLP, resident in our Boston office. I have a broad-based intellectual property practice in which I work across patents, trademarks, designs, copyrights, and trade secrets. Within the cannabis space, I've done a lot of work with clients on identifying new brands, clearing those, and then protecting and enforcing them.
Wonderful. Thank you, Brian. Let's go to Tammy next, then we'll go to me. Tammy, a few words about yourself.
Thank you, Melissa. Hello, everyone. Currently I have a policy shop in Washington, D.C., and so I work on cannabis policy and other FDA regulated categories and lobby, actually. I started my practice out of law school doing criminal defense work, and then that transitioned into food and drug law and served as in-house, outside regulatory counsel, GC type work, and that evolved into straight policy work. So that is what I'm doing now. Thank you.
Thank you. And then myself, with much blonder hair nowadays, Melissa Rody, with Sonara Silikowski Tomaska in Seattle, Washington. I started doing cannabis work in 2016. I took a seminar in Boulder, Colorado, where the Dalai Lama was speaking. So I had the choice of hearing the Dalai Lama or learning about cannabis. I stuck to my guns, and I've been doing it for the last 8 years. I primarily focus on premises liability cases, products liability cases, and then drafting, reviewing policy and procedure employment manuals. So intellectual property isn't in my wheelhouse, so I'm excited to learn and add any of the few tidbits that I may have to have this program progress. So our first category is trademark challenges. Question number 1 for our speakers. What are the most common trademark issues that cannabis businesses face, and how can we navigate them? So
Sure. Yeah, I can jump in. So the first challenge that we see for our clients in the trademark space is something that's not necessarily unique to trademarks, and that's freedom to operate issues. And that's your ability to use a brand without potentially violating somebody else's trademark rights. And so that's an issue that's somewhat universal. That can happen to, it's a risk that clients in the banking industry can face or the cannabis industry. What can be unique to cannabis is that given that there's obviously some legal wrinkles that have been discussed in previous episodes, cannabis companies may not necessarily be as appreciative of those risks as other companies that are outside the cannabis space. Where we see some unique challenges is with regard to the federal stance towards trademarks, and that manifests itself at the USPTO. We'll talk about this, I imagine, a lot during this session, but there's a lot of nuances in the ability or inability to register cannabis trademarks at the USPTO. And basically, we see a distinction between plant touching products in which it's difficult to impossible to register those at the USPTO versus promotional items such as t-shirts or services, informational services, where we can register those. And that creates the need for a different trademark strategy relative to other businesses. And then in view of that, given that the USPTO is not the one-stop shop that it is for most other industries, clearance in the trademark space of new trademarks takes on a number of different wrinkles because unlike really any other industry we work in, we have to be mindful of, well, is somebody registering or using this just in Pennsylvania or just in Michigan? We look at so many more markets in the cannabis space than we do for most of our clients, where there's really just a lot more federal primacy.
Brian, you already generated a question. This is a record. We haven't had a question this quickly before. So the question is there a rub against trademarks which seem to be regulated federally and the federal illegality of marijuana? Is there some kind of disconnect or problem between these two concepts?
Yeah, so yes, and the reason that exists is that it goes back to the constitutional underpinnings of our federal trademark registration system. Unlike patents and copyrights, which are set forth explicitly in the Constitution, Congress's authority to create a federal trademark system arises under what's called the Commerce Clause. And as a result of that, what the USPTO and courts have held is that there's a federal legality requirement. Basically, in order for the protections of the federal trademark registration to be granted, it needs to be for commerce that, one, Congress could lawfully regulate, and a commerce that is actually lawful. So, for example, what we saw when the 2018 Farm Bill was passed, and that allowed for hemp as legally defined to be federally legal, the USPTO took the position that if there were existing trademark applications, those were not permitted to maintain their earlier pre-Farm Bill date, because at the time that those applications were filed, the goods, even if somebody had the prescience to recite the exact language of the Farm Bill for the goods and services, that still wouldn't have been legal at the time. Going forward, you could, and then of course, there's still a large amount in the cannabis space that extends beyond the Farm Bill and would still be rejected by the USPTO.
Yeah, and with the Farm Bill, my understanding is, has it expired or is it getting extended from the 2018?
I honestly don't know exactly where the status is. I think, like a lot of things in Congress, probably everything is up for negotiation. I saw Tammy came off mute, so I'm hoping she can answer that.
Yeah, Tammy.
Yes, thank you. And Brian, I did want to reach back on something that you touched on in that response as well. But yes, as far as the Farm Bill, it's that 5-year must pass legislation. And so it was in 2018. We are operating under a continuing resolution or just a continuation of that package right now. Just very briefly, the the chair of the Senate Agriculture Committee is Senator Stabenow out of Michigan. She's a longstanding member of Congress, and she has chartered previous Farm Bill packages. So she is leaving Congress, and so this package will be part of her legacy. Over the last several months, we were not hopeful that a Farm Bill would get completed before the wrap of this Congress. And so there are two things. There's a little more appetite now to come to the table and to sort what a farm bill look like. And of course, outcome of the election, just for the composition of Congress will certainly play into this. But there's a little bit more appetite to try to advance a new farm bill, or we're looking just at another extension of the 2018 Farm Bill.
All right. Next question. When federal trademark registrations aren't available, what options do cannabis companies have?
Sure. So as I mentioned earlier, as I teased earlier, because federal registrations are limited, we tend to look more to the state level. And that's what we see most cannabis companies do, in that either there's a reliance on common law trademark rights, which are generated by use of a trademark in commerce, whether or not there's a registration filed, or state level registrations where a company may register in California or Pennsylvania. The other thing that we it certainly is available, but we don't see used as often, probably because of either the cost or, in the case of copyright, the lack of a compulsory registration system, is copyright and design patents. As I mentioned earlier, copyright and patents are explicitly enumerated in the Constitution, so therefore we don't have the legality issues. So somebody could register the design for a bong, and as far as the USPTO patent side is concerned, that would be completely fine. Whereas if you tried to register Acme brand for bongs, you would have a problem.
Cool. All right. Right. Well, we kind of talked about this, just touched on it. How do state trademark registration systems differ from the federal system? Anything additional to add, Brian?
Yeah, it's actually quite a lot. And it's interesting because for a lot of trademark attorneys, and for really anyone that's interacted with the trademark system in any other industry, this is probably the one and only time you'll interact with the state trademark system in your career. So there definitely are some differences. One of the big ones is that there's not an intent to use option. So for most of our clients, if somebody comes to us with a new business or a new brand they're launching, federally, we would typically file what's called an intent to use application. And that potentially gives you upwards of 3.5 years to get your application examined and allowed, subject to showing use in commerce, while you grow your business. But at the state level, we don't have that. So everything is based on use in commerce. And in particular, with regard to, given the balkanized nature of different states and the licensing requirements, that creates a need for a lot more coordination. So if a client is going to launch in Massachusetts, for example, we need to wait until the client actually starts selling goods in Massachusetts. Now we can coordinate with them and have the application ready to go on the Monday they launch, but it's definitely much more, there's a lot more applications involved, especially for multi-state operators, than there would be if we were just doing federal registration. A couple other smaller distinctions. Generally speaking, it's one application per class, which is different than the multi-class systems that we're used to at the USPTO. We've found that online databases can be somewhat stale. Some states have gotten better about this, but I remember when I first got involved in the cannabis industry, we had done a search for a client, and were rather surprised when the client said, well, what about these registrations that they knew about because they had filed them with prior counsel? But we went back and checked, and sure enough, that particular state hadn't released results or hadn't updated its database online in 5 years or so. So there was just a huge black hole. And then lastly, some states, particularly California, really examine the specimens of use that we have to submit, not just for trademark substantive requirements, but also for cannabis labeling regulations. So they're really looking for an honest to goodness label that, as far as they're concerned, meets whatever the cannabis labeling requirements are in that state. So it's not enough just to submit the front of a packaging, which shows the brand as we would typically do. But you really need to see the back so you can see what the weight is, see that there's the cannabis symbol. And if that's not missing, your filing will get rejected.
Yeah, someone who does a lot of litigation like me, having this 5-year black hole, it seems really problematic. All of a sudden, you think you're doing the right thing, nothing pops up. You start creating your product and your branding and your marketing, and all of a sudden, you've got somebody else's process that they started for you. And I guess it's, the first date that has been marked is the person who has the ownership of it. Is that how it would work?
Yeah, I mean, we don't see a whole lot of registration or a whole lot of disputes at the state level just because, this is all relatively new. But I mean, that would be my starting assumption.
Yeah, yeah.
Melissa, may I ask another question of Brian on this topic?
Yep.
So Brian, as part of when a client is considering a mark or a packaging, would due diligence, if there was some type of prosecution on the state level, but if the client was able to show due diligence in vetting, sorting, and seeing if there was other use of whatever their mark or packaging is, would that be valuable?
Yeah, it's certainly a helpful fact, even if the prior applicant was deemed to actually have trademark priority. At least that would be a helpful fact in trying to avoid any allegations that it was willful infringement. Because basically you could show that you took commercially and legally reasonable steps to try to identify this, but for this blackout, which and trust us, we really do want to find this stuff. You just can't figure it out sometimes.
Yeah. All right. Would proposed rescheduling of cannabis affect the ability to obtain federal trademark registrations?
Yeah, so the lawyerly answer is I honestly don't know. So the reason I say that is that there are trademark registrations for current Schedule III drugs, such as ketamine therapy. There's also trademark registrations for other things that the average consumer can't buy, such as high explosives, or even Lockheed Martin has a registration for F-16 in connection with fighter jets, but you can't go and buy those no matter how many millions of dollars you have. So the real question to my mind is, assuming that the rescheduling goes through, is there going to be a market for the sale of cannabis under Schedule III regulations? Meaning, again, go back to the ketamine example, you can obtain ketamine under a prescription from a licensed physician, but you can't just go down to a dispensary and get it for recreational purposes. So it's not clear to me whether even in states or even where there's a significant medical market, will the industry ultimately want to sell in a way that complies with whatever regulations the DEA imposes under rescheduling? Or is this simply just going to be a situation where the industry gets the benefit of the unfavorable tax treatment going away under Schedule 280E, and then we just don't see a Schedule III compliant market spring up?
All right, we're moving on. Branding. All right. How does cannabis branding differ from other industries? And I'm happy to start this one off and then see if you two have anything additional to add in. I think on the logistical side, it doesn't differ at all. And so it has the same goal, getting your product out there, getting it popular, getting exposure to it. I think that there are a lot of state regulations around branding a cannabis product. And I know that in a couple slides, we'll talk about more of the specifics. But the biggest thing that I have seen in the branding market for state, not through federal, is really protecting the children. You always hear this about protecting the children. And what does that mean? We are trying to not target branding to minors. And that has been a big part of even thinking about the jewel and the vaping and that very much the targeting of a certain sector of minors, which has caused huge problems and litigation for them. So I'll talk about some of the specific brandings that I've seen, at least in the Pacific Northwest, here in a couple of minutes. But that's the biggest part of branding that I have seen that really differs for the cannabis industry. Tammy?
And Melissa, I may be jumping ahead, but that's exactly right, the youth access bit. And I also find that certain your commonplace media channels or where you would want placement, advertisement placements, or even a presence, a booth, that there are certain limitations around cannabis type products.
There are billboard placement. Yes, lots of things along those lines.
Yeah, and then from the registration perspective, the plumbing underneath is a bit different than most other businesses. We've talked a lot about how that looks in terms of registration. In the case of multi-state operators, where we're going to have the brands going across, across the country, in some cases, at a state level, in addition to potentially needing individual state level registrations, just for regulatory reasons, that there often needs to be distinct companies that are operating in those individual states, which is different than other, a national shoe company is generally going to be the same company that's selling into each state. But we see a lot, corporate structures being a lot more nuanced here, which creates a need for licenses, for example.
So what does that mean for the state regulations? I think companies that are going to be selling products in multi-state have to be aware of what each state is regulating. For example, in Washington state, the cannabis is essentially governed by the Liquor and Alcohol Board. It is one board for all of these different products. And they are regularly updating what can be put on packaging. It goes down to the font, the colors, the location on the packaging, certainly the logos, anything that looks kid friendly, especially on an edible product versus a flower or shatter type product, is highly regulated. For example, hot pink, can't use it in Washington state, can't be on an edible product because it is attractive to kids. A rainbow and a unicorn and a heart and some stars around it, probably not going to be available to you. It certainly will need to be submitted for approval. So if that is allowed, let's say in a different state and star is your logo, it may not be allowed in Washington state. So multi-state sellers for these types of products are going to have to check with each board or regulatory system in each state so they can have consistent branding, because what you create in Pennsylvania may not be allowed in Washington state. All right. Copyright. How does copyright law apply to cannabis branding, particularly in terms of logos and marketing materials?
Sure. So, first, that gravity still applies, at least legally. Cannabis companies can still be sued for copyright infringement, as well as violating other types of IP. And where this can arise, for example, is lots of people in all sorts of industries have a general perception that if you find it on the internet, then it must be free to adopt and use, and that is not the case. Although there are good search engines that, for example, can let you see what things might be available under the Creative Commons licenses for potential commercial use. So that's one area. As I mentioned before, copyright doesn't have the lawful use in commerce requirements that we see in trademarks. So I think this is potentially an untapped area where companies can try to obtain protection for their overall branding. It's not going to protect a particular word, and there's also some limitations on protections or at least copyright registrations for very simple logos. But for more elaborate logos and packaging, copyright may be a good vehicle for that.
Yeah.
One of the nice things about copyright is that the protection accrues at the point that it's fixed in tangible media. So, for example, copyright applied when the PowerPoint that we were using was saved to a computer disk. That's both a blessing and a curse. It's a blessing in that you don't have to do anything more. The curse is that registration often is really helpful if you're going to need to enforce it, because it's a requisite to bring suit, but also it's a requisite for statutory damages, which can be a very helpful tool to bring into any sort of dispute with somebody. But you only get those statutory damages if you register before the infringement occurs. So for that reason, it's often the case that as lawyers, we find out about the problem, then we get the registration, so you don't have as strong of a damages case to bring.
Yeah, I think the biggest infringement I've seen is everyone seems to want to have a play on the Starbucks mermaid logo here and try to adopt that for a cannabis type product. And so far it hasn't gone very well for any company who has tried to seem very familiar with that Starbucks logo. What are some effective strategies for cannabis brands to differentiate themselves in a crowded market? I see a lot of this when I go to one of the major conferences, which is down in Las Vegas each November, the NJ Biz. And it seems like things are getting, each year I go, more extreme, louder, brighter, if it's allowed. And that people are running at a very quick pace and they haven't potentially slowed down to figure out if it's going to be problematic for them. But I think right now, the biggest thing that I have seen is getting big name recognition with your product, getting the Willie Nelson brand, getting the NBA and NFL backing. The NFL has been really a big proponent for the medicinal use of a cannabis product to get their players off opioids and different pain management. So one of the most effective strategies that I think is trending right now, if you can afford it, is associating yourself with the bigger names out there.
Melissa, if I may just add to the celebrity endorsement, yes, is definitely catching the headlines and consumer with the recognition of that. Another, which I find is almost unique to cannabis, I think it can benefit multiple product categories, but it's definitely helped in the cannabis space because you have policy and legal battles on the local, the state, and the federal level, and that's community engagement. Whether it's through food banks or animal rescues or sponsoring different events within the community and really being involved in the Main Street economy and Main Street affairs for particular communities.
Okay.
And from a trademark perspective, one of the biggest areas where we see companies get tripped up is not doing that clearance searching up front. what can happen in that situation is if we can look at brands, and ideally when we're clearing things, we encourage our clients to come to us when they narrow it down to about 3 different brands. And the reason for that is every trademark or potential trademark has warts. And if you come to us when you're down to 1, we often see a lot of lock-in, especially not so much financially, really it's emotionally, because it takes a lot of work to get to these things. And you hate to see our clients crestfallen, or potentially deciding to go ahead even in view of the risks, just because they're so invested in their brand at that point. And then if you go down that road, you can find yourself in a situation where, in order to try to avoid any sort of infringement accusations, we're taking the position that, well, the market can tolerate our brand because there's 5 other brands that are similar to this other company. And that's really just coming out of the gate and saying to the USPTO, the market, or the courts, we have a weak brand. And that's not a great foundation to build an investment on through the strategies you were talking about.
Sure. Who's the target audience? It's an incredibly broad question. Who is your target audience? Through the research that I've done and the seminars I've attended, the biggest growing product is the edible market over the flower market, the tincture market. And so kind of these more application and edibles versus the smoking product that we've seen. One of the largest growing populations is the senior population. And I think that has been evident through so many states agreeing to medicinal products, but not necessarily recreational. I probably should have done a count, but I think we're at 38 or so, please give or take 1 or 2 for the medicinal market throughout the US for legalization, and only around, I think, 24 right now for the recreational or adult use market. So target audience, if you're wanting to go that way, I think can be our senior market, and also trying to replace the opioids out there and using this for medicinal uses. And I see a lot of advertising towards medicinal uses, which has this whole litigation in and of itself on what you can say a product can do and what a product can't do. So Tammy and Brian, any thoughts on target audiences?
Yeah, I mean, one thing that I'm seeing is I think cannabis operators are definitely becoming more focused on developing particular brands for particular audiences. And that's really helpful information to us to communicate to us as trademark counsel, because, to use your example, Melissa, if this is a brand that's going to be targeted to senior audiences, well, then maybe we're more concerned about other brands that are focused in that market than we would be if this was a product that's targeted to 20-something women.
Sure. All right. How can cannabis companies leverage storytelling to build a strong brand connection with consumers? Tammy, any thoughts on this one?
Well, I do. So again, almost unique to the cannabis space, it's this notion of authenticity. The cannabis industry, I think the consumers and the end users are quite savvy, that and you mentioned the senior population, they are looking for alternatives or something because something isn't working in their life or with their current regime. And so they will ask questions. And with that, not only about the safety and efficacy or different characteristics on the profile of the product, but brands, they often tell a story to set themselves as their POD in the marketplace, and consumers will ask questions about the product itself and about the story. So and they're in this space. We even have brands that have been launched by the aging population. and the veteran-owned population and multiple different populations. But what I find is you need to be authentic and genuine. Certainly when we're delivering messages in DC, we receive pushback, and they're like, really, are you sure are you sure you work with the farmers? Are you sure you, and it's the same with the consumers. Consumers are very savvy. So if you're going to have a story, and if you're going to tell the story, it better be real.
Sure. I've also seen one of the big growth here is the, going organic and trying to keep off the pesticides. And the story really is, wholesome growing and wholesome production for this. And that plays well in the Pacific Northwest. Maybe it wouldn't play well everywhere, but that's really important to this population, is having something that is going to be beneficial to you and also not harm your body in different ways. How important is social responsibility? And I think you just touched on that, Tammy. And for us, what I'm seeing is there is kind of a lot of hot growing out here. So when you have the outdoor grow and not the indoor grow, having these products that are coming out pure, and that is a social responsibility that our consumers here, at least in the Pacific Northwest, want to know about. And if a product, and I'm dealing with a lawsuit right now, if a product is hot, that means there was something in the ground that is affecting the product that you didn't necessarily put in there, but through all the years of agriculture, there was a chemical in there that is now coming up to the surface and affecting the growing of that plant. Now it's testing different than maybe it did 3 years ago, even though you're growing in the same location and growing the same type of plants. What do we need to tell our consumers? Do we need to pull products off of the market because they are a hot product? And for me, it's very much a social responsibility. If you want longevity in this field, you have to get in front of it. And you have to be very, again, like you said, Tammy, authentic about what may be going on and telling your consumers the same thing. So they'll want to come back to you in the future.
Just briefly, Melissa, to build off that, what we are also finding, it's this level of transparency all the way down to a particular SKU. How many other product categories do we know where if you have a QR code or a link to a brand's website, can you track a certificate of analysis? I mean, we've seen supply chain measures where there's heightened transparency on the origins of either raw material or a piece of clothing, but it's pretty granular when you can look at a C of A for a particular SKU. And so, and that's goes back to what you're saying, even the region where the material was grown and then the conditions of that grow as well.
Good. All right. How important is digital marketing? Yeah, I think it's one of the maybe most affordable ways, and for the largest volume of potential viewers is our digital market. You have your Instas and your TikToks and your, aging myself because I don't think it's cool anymore, but I still do it, your Facebooking out there. I think it's huge. And for me, if I was talking to clients about getting the best bang for your buck, I tend to think the digital marketing is the way to go. But, playing off what Tammy said, being authentic about it, being catchy and trendy, but having a very focused marketing on who you're going to target. All right, intellectual property. Are there any other types of federal intellectual property protection that might be able to backfill in the view of the limited ability to obtain federal trademark registrations? Brian.
Yeah, sure. So we talked about copyright and design protection earlier. And so just to recap, design patents are something that protects the ornamental aspect of paraphernalia, packaging, et cetera. Copyright is going to protect the potentially the artwork, or it can extend to three-dimensional designs. So those are the ones that are best suited to backfill from trademarks. That being said, it's also worth thinking holistically about your product and considering whether there might be other types of IP that, although not necessarily backfilling, can augment. And those include utility patents, which could include, for example, a new method for extracting CBD oil or a new vaping device. They can include plant patents, which cover asexually produced distinct and new varieties of plants. And then also there's trade secrets, which can include lists, methods, and like that provide commercial value, so long as they're not widely known by others.
What strategies can cannabis businesses use to enforce their intellectual property rights in a rapidly evolving market?
Yeah, so there's different services out there that we recommend to our clients, and those include watch services and internet monitoring. So what watch services do is provide alerts to either attorneys or clients when trademark applications are published for opposition. And the reason that these provide value is that in the US and in other locations, trademarks are published for opposition, during which time you can potentially either put the application on hold by requesting an extension of time or file an opposition and try to prevent somebody else from registering that mark. But the windows for doing that are relatively short. In the United States, the USPTO, it's a 30-day window. So if you're trying to rely on discovering these things just by happenstance, experience suggests that's not going to work out very well. So watch services for a couple $100 per year provide a systematic way of doing that. Similarly, internet monitoring can help us discover that somebody might be launching a business. And with both applications as well as use, what I found over my career is the earlier that we can find out about something and reach out to somebody, the easier it is to reach a favorable resolution. We talked about lock-in earlier. That's very much the same when somebody's using a brand. If we can reach out to them before they've either made the emotional investment or a significant financial investment, we have a lot more options versus reaching out to them when all of a sudden their business is taking off and booming, and we're now asking them to potentially rebrand.
I have another
Yeah.
question. Go ahead, Tammy.
Well,
Go.
that's exactly right, Brian. And I will say, because it is a rapidly evolving market, the other thing, so you have the monitoring service, and when something is detected, because even though dollar value, this is a pretty decent sized category, it's a fairly small community. So whether you have in-house GC or outside, pick up the phone, have the conversation, and be ready with a cease and desist letter, because but I just encourage and recommend to try to keep things as cordial as possible. And so far, most brands, they appreciate, because it's such a competitive market space. And so, but yeah, that's just to be ready with that phone call and a C&D.
Question that came in. Is there an intellectual property or copyright relationship that you're aware of between cannabis companies and any type of alcohol or tobacco product that is currently on the market?
So I'm not aware. I'm not aware of any IP relationship, and I can't think of any. For example, using trademarks, I can't think of a situation where somebody has licensed a brand that might be used on beer to also be used in connection with cannabis. I mean, I am aware just from the press of different alcohol companies, for example, making investments in the cannabis space. Although I'm not sure exactly where those stand at this point.
Yeah.
Right. And in addition to that, Brian, just on the business partnership, not necessarily a licensing of any type of IP, it's the same on the tobacco side and in the vape space.
Yeah.
Yeah, the only thing, again, I can't talk about the IP, but I've seen out here at least a lot of the craft CBD beers and seltzers, which are extremely popular. So a big one out here might be like the Rogue Brewery are dipping their um investments and branding also into CBD infused beverages
Mhm.
that I've seen. All right. What key considerations should be included in licensing agreements for cannabis related intellectual property?
Yeah, so I'll preface this by saying that I'm very much not a licensing guy, and will often pull in my partners when these things come up. From a trademark perspective, one of the things that always comes to my mind when I'm looking at an agreement is there a quality control provision? From a trademark perspective, we want to make sure that we avoid what's called naked licensing, and that can lead to the basically the trademark ceasing to act as a source of quality control. So if I just say, okay, Tammy, you can use my mark in Washington, D.C., and I don't say that I have the right to control how it's packaged, what goes in the packaging, basically my mark no longer acts as a source of origin or a source of quality. So that's why we need quality control provisions. A couple other things that also come to mind, just given the unique nature of the cannabis market, is geographic scope matters a whole lot more than it often does in a lot of other businesses. We have new states that are coming online. We have states where even though it's legal, some companies may not want to play in that market because they feel the economic and regulatory structure just isn't favorable at this point. So there's a lot more flux in terms of what the market's going to be. And unlike a lot of other businesses that our clients operate in, that there's so much more regulatory and licensing compliance. And so many times, the ability to use a brand is contingent not just on having a license from the brand holder, but ultimately having and maintaining a license from the state. So there's a lot more moving parts on that side than just the brand.
Another question. Gotta blow it up so I could read it. Um, how do you think intellectual property will change or how businesses may be consumed when cannabis in the recreational sense becomes federally legal?
Yeah.
Paren, haha, close paren.
Oh, sorry, I missed the quote. Parenthetical.
Paren, whenever that happens, haha. I think they're making fun of how long
Yeah,
it.
no, understood. And I certainly won't try to predict when further federal liberalization beyond rescheduling will happen. The most interesting thing for me, and I really don't know how this will shake out, is what the federal stance will be with regard to the very significant number of state legal operators right now that are using brands, in a way that is fine with California or other states that have legalized, but from a federal perspective, is not legal. Earlier on, we talked about how the USPTO handled this once the Farm Bill came online. And from their perspective, it was kind of a land rush when the Farm Bill became effective, in that anybody could file and they weren't going to give any consideration to what had happened pre Farm Bill hemp liberalization. That, given how robust the cannabis market is at the state level, doesn't seem to make a whole lot of sense to me. But I mean, you could certainly imagine from a federal perspective how they may say, well, that's great that everybody's been using this for all these years. We're just going to ignore that in a bit of a legal fiction.
Just very briefly, I agree, Brian. I expect a tremendous uptick in certainly the submissions for different TM applications, how the office nets out on that. And then the other thing that I think is very interesting, even from the intellectual, just the exercise of it, is that IP and TM portfolios conventionally are a nice asset in a business portfolio. And the cannabis industry hasn't necessarily had that, or at least not the full value of that. And yet the cannabis industry and business valuations are still, I know you can deconstruct those numbers quite easily, but at least the numbers are still running high. So I would expect a tremendous, significant number of submissions.
That's a good plug for Friday, which will be evaluation of businesses. All right, our last category, and we have 10 minutes left. Patent protections, types of cannabis-related inventions that can be patented and the challenges obtaining these patents.
Yeah, so we talked about the three different types of patents: utility patents, plant patents, and design patents. Rather than go through what those cover, let's talk about challenges a little bit. So one of the big things that you need to keep in mind with regard to any of these types of patents that isn't an issue with copyright, isn't an issue with trademarks, is that with patents, because there's an overarching concern about public disclosure versus the freedom to actually practice the invention when it's not subject to patent protection, we deal with what we call bar dates, meaning that if, let's say, Melissa publishes an invention, starts commercializing an invention, even if it's an idea that I came up with myself, and she does that independent of me before I filed, then Melissa's work is going to constitute prior art to my invention. Now, I may be able to still get a patent on my invention if I can show that whatever I'm claiming is non-obvious over what Melissa was doing. But you can also create prior art to yourself. So let's say that you launch a product in January 2022 and you didn't file for a patent on that product, whether it's out of just ignorance of the patent system, or maybe you didn't think the product was going to be that commercially significant. Well, if we're now in 2024, you've really lost your window to file, at least based on what was actually sold, what was actually disclosed. There may be new improvements that you could focus a patent application on. But bar dates really are an area where, as a patent attorney, we spend a lot of our time and focus on that. So that's probably the most important thing to know about patents for somebody that's new to this space. Be aware that there's bar dates and reach out to your patent attorney early and often.
Right. Okay. Oh, we do have one more. Trade secrets and then our predictions. Trade secrets. How can cannabis companies effectively protect their trade secrets, especially in cultivation and product formulation?
Yeah, so trade secrets are somewhat analogous in terms of how we go about protecting them to copyrights, in that because there's not a registration requirement, or at least compulsory registration, that there's no registration at all for trade secrets. We often see a situation where a company may have a trade secret, but because they didn't face those bar dates that we have with patents, they weren't forced to go to an attorney, and therefore they didn't. We find a much shakier evidentiary trail often, in that client has a hazy idea, they have a trade secret, they haven't identified it, and we really can't show a whole lot, or it can be challenging to show what steps they took to protect it. So the three steps I would suggest for a trade secret, and again, all of this also involves talking to an attorney, but identify your trade secret with some specificity, adopt appropriate measures to protect the trade secret, and then actually follow through on those measures. If you can do those three things, you're putting yourself in a much stronger position to actually be able to enforce a trade secret if a former employee moves on, for example.
Very briefly, if I may, Brian.
Yeah, please.
So we haven't seen the Coca-Cola recipe yet come out of on the cannabis side yet. However, cannabis brands often work with multiple vendors And so one of the things that Brian had mentioned is develop your SOP or your protocol on how to, after you identify your trade secrets. Yeah, NDAs, confidentiality provisions in every agreement possible to include with your employees, because you just never know when you're going to have that Coca-Cola recipe come from it. And because you have so many outside eyes, are, have privy to so much of your information when they're working with you. And we also see some employee turnover. So those are my other two recommendations.
All right, perfect timing. Let's get to future trends. How about we each talk about what our predictions are or what we think our trends are? So, Brian, I'll start with you. Thoughts on trends and predictions for the IP trademark market?
Yeah, so the question that was asked earlier really stole my thunder on this one. I suspect federally we're eventually going to get there. And then the real question for me is exactly how we acknowledge prior state legal trademark users.
All right, Tammy.
Well, this might not be spot on, but I'm going to connect it to my wheelhouse and what I do. Just that branding and IP and how brands interact with their marketing and in the public domain can either help or hinder what we're doing on the policy level. So they're very much tied together. And so we are seeing, out of the gate, there was all this concern about youth access. And I'm not a proponent of micromanaging in the marketplace as far as like, no, you can't use the color pink. I just take great issue with that. And so we are seeing the market mature, and hopefully we don't have to micromanage and be that granular. So the future trend is just as the market matures and consumers are more familiar with this product category, there'll be some more PSA and national messaging around this, that we will see that reflected in policy and more favorable market conditions is my prediction.
All right. Want to end this with thanking some additional sponsors. The Daily DAC, to stress Asset Central. Thank you for being with us and sponsoring each of our cannabis episodes. We have Thomas Reuters and the ebooks that are available through them. Mood, once again, thank you, Mood. Thank you, Type to Learn. Thank you, Mass Access. And thank you, Financial Pulleys, for inviting us to speak and talk with your audience. Any last parting words, Brian or Tammy, for our audience?
Just thank you and our audience and Financial Poise. This is a great program.
Awesome.
I second that. And for people attending, CLE.
Well, this was our record on having the most amount of questions so far in a presentation. So congratulations to our speakers for engaging our audience. This is Melissa Roeder. On behalf of myself, Tammy, and Brian, thank you for attending and have a great day.
Thanks.